Hola, muy buenos días a todos. En nombre de la Junta Directiva del Grupo IFA Panamá, queremos darle la bienvenida a todos los miembros IFA, a los no miembros, a los distinguidos panelistas que tenemos el día de hoy, a nuestro primer webinar como nueva Junta Directiva. Antes de iniciar, quisiéramos hablarles un poco rápidamente sobre lo que queremos hacer, nuestro plan como Junta Directiva en IFA Panamá, y contarles pues que tenemos planeado un plan que involucra la participación activa de los miembros. Hemos creado comités de trabajo. Les voy a contar un poco. Tenemos el comité técnico, que es un comité que abarcará los temas relevantes en la tributación local y la tributación internacional. Este comité está liderado por Klaus Vivarach y Javier Mitre. Tenemos el comité de precios de transferencia y economía digital, coordinado por José Galíndez. Un comité que ya tiene unos años de estar creado es el comité YIN. Para los que no conocen, las siglas significan Young IFA Network. Es un comité dedicado a los miembros IFA más jóvenes, menores de 30 años. Y este comité está coordinado por Ana Cristina Valdés. Tenemos el comité que se llama WIN. Este comité es el comité para miembros mujeres IFA, es Women IFA Network, y está liderado por Lilia Lee. Y por último, hemos creado el comité para precedentes, publicaciones, para publicar documentación en línea, nuestra página web, en redes sociales, información relevante para los miembros IFA que vamos a tener el acceso privado para aquellos miembros, y el comité también se va a encargar de lo que es la participación activa de los miembros, atraer miembros nuevos y promover lo que es IFA, coordinado por Amanda Barraza y Ibsen Ávila. Además, les quiero contar que hicimos una encuesta a los miembros y esta encuesta dio como resultado que la mayoría desea que tengamos una participación, que hagamos actividades mensuales, que están muy interesados en participar en investigaciones, en publicaciones, en temas siempre tributarios relevantes para nosotros, y en actividades de responsabilidad social para promover lo que es la cultura tributaria y la educación. Y con esto invitamos pues a los participantes que no son miembros a que se afilien a IFA Panamá, y a los no miembros que se afilien, y a los miembros que participen en nuestros comités, y pueden encontrar más información en nuestra página web. Nos pueden escribir también a nuestro email. Y con esto me despido, dándole la palabra a Klaus Vivarach para que dé inicio a este evento del día de hoy. Bienvenidos todos, gracias.
Buenos días a todos y gracias por su presencia y su atención. Primero debemos iniciar dándole las gracias a estos tremendos expositores que tenemos, Hans Luis y José Carrizo, ambos con mucha experiencia, tanto Hans a nivel internacional sobre tributación y arbitraje, y José sobre el arbitraje en Panamá. El arbitraje tributario en Panamá fue introducido en el Código de Procedimiento Tributario, cuya entrada en vigencia ha sido dilatada un poco, pero observamos que el arbitraje está tomando bastante fuerza en el ámbito tributario, no solo por el aumento de los litigios o las controversias que se pueden estar generando por esta necesidad aumentada de recaudación en medio de esta pandemia, sino que hay varias iniciativas a nivel internacional de que el arbitraje ya pase a un arbitraje mandatorio o obligatorio para, por ejemplo, en el ámbito de la tributación digital. Y por eso entonces lo que queremos o nuestros objetivos dentro de este webinar es primero conocer qué experiencia ha tenido el Estado panameño con los arbitrajes, y luego vamos ya al área internacional para ver qué significa el arbitraje para países en desarrollo. Entonces, primero quiero darle la bienvenida a José Carrizo, que es socio encargado del Departamento de Litigios y Resolución de Conflictos de Morgan & Morgan. Lidera un equipo dedicado a asesorar a clientes en temas de litigios, resolución de disputas comerciales, derecho penal y arbitraje. Ha participado en casos complejos, especialmente en áreas de derecho civil, penal, administrativo, comercial, bancario, insolvencia y seguro. A lo largo de sus más de 20 años de carrera, su experiencia abarca todos los procedimientos de litigios que comprenden la legislación panameña ante los diversos órganos jurisdiccionales de la República de Panamá, incluidos tribunales civiles, administrativos y penales. José, bienvenido.
Muy buenos días. Agradezco a IFA la gentil invitación pues, que se me extendió para participar de este interesante foro. Quisiera hacer unas breves reflexiones sobre el tema de arbitraje y luego compartir brevemente lo que ha sido nuestra experiencia en arbitrajes en lo que el Estado ha sido parte. Como ustedes saben, el arbitraje tiene una base consensual. El arbitraje inicialmente se encontraba regulado en el Código Judicial que data de 1917 y en el mismo Código Judicial se establecía el procedimiento que debía seguirse en arbitraje y los mecanismos de impugnación del laudo una vez dictado, que entonces consistía en la presentación de recursos de casación en la forma ante la Sala Civil de la Corte. Posteriormente, y siguiendo una evolución interesante a tono con lo que ha sido la tendencia hacia el arbitraje moderno en las diferentes legislaciones, se aprobó el Decreto Ley 5 de 1999, que reglamentaba de manera especial y autónoma la institución del arbitraje, y ese mismo decreto fue posteriormente reemplazado por la Ley 131 del 2013 de arbitraje, pues que regula tanto el arbitraje internacional, local, institucional y ad hoc. Creo que es importante en lo que respecta al Estado recordar que en el año 2004 se introdujo una reforma constitucional que implicó que según el artículo 200, numeral 4 de la Constitución Nacional, el Estado declara la validez de todos los convenios arbitrales en los que el Estado sea parte. Esta modificación fue interesante porque antes de esa reforma del 2004, para poder comprometer eficazmente al Estado en un proceso de arbitraje, se requerían algunas formalidades previas, entre las cuales estaba el concepto favorable del Consejo de Gabinete y visto bueno del Procurador. En este caso, con la reforma del 2004, el Estado, vía esta disposición constitucional, de entrada se somete válidamente a cualesquiera disputas contractuales en las que el Estado haya acordado, bajo la libre autonomía y voluntad de las partes, la inclusión de una cláusula compromisoria dentro de esos contratos. Y eso es lo que ha permitido precisamente esa legitimidad que viene por ese acto constitucional y demás leyes que han reglamentado el arbitraje, ha traído consigo procesos arbitrales en donde el Estado ha sido parte, procesos de arbitraje tanto locales como internacionales, en el último caso basados en los tratados de protección de inversiones, creo que no necesariamente vinculados a aspectos tributarios, pero sí al tema de protección de inversiones basados en los diferentes tratados que se han suscrito. Estos son arbitrajes que generalmente se llevan a cabo bajo la regla CIADI, pero con esto lo que le quiero es compartir que en efecto pues el Estado se está moviendo, dada esta tendencia hacia el arbitraje, a convenir no solamente cláusulas compromisorias, sino aceptar la validez de las mismas, aunque hay algunos retos que todavía se enfrentan y que han sido motivo de algunos pronunciamientos por parte de tribunales arbitrales. Y es que el Estado, en alguno de esos procesos de arbitrajes, al menos arbitrajes locales, no ha sido infrecuente que el Estado oponga dentro de esos procesos de arbitrajes algunas prerrogativas procesales que se encuentran en el Código Judicial, específicamente en el artículo 1939 del Código Judicial, que establece básicamente que el Estado goza de algunas garantías o privilegios, dentro de las cuales está el derecho de que todas las notificaciones que se hagan al Estado se hagan de manera personal, es decir, no a través de los mecanismos que facilita la ley de arbitraje, que no necesariamente se apegan a esa rigurosa formalidad o formalismo al que se refieren los procesos judiciales. Y otra que me parece supremamente importante es la disposición contenida en el 1939 del Código Judicial que le impide la solicitud y obtención de medidas cautelares contra el Estado. Y es que las medidas cautelares resultan fundamentales en un proceso porque a pesar de que el arbitraje está llamado a ser resuelto de una manera cortoplacista, por así decirlo, recordemos que indistintamente que el arbitraje sea local o internacional, en la medida en que se aplique la ley panameña, la decisión que se profiera en virtud del laudo permite la presentación de recurso de nulidad o de anulación ante la Sala Cuarta de Negocios Generales de la Corte, y digamos que ahí se judicializa un tanto el tema, porque evidentemente, debido a los tiempos que manejan, pues a veces nuestros operadores de justicia, un arbitraje puede darse un laudo en 6 meses, 1 año, pero a veces el recurso de anulación puede tomar incluso más que todo lo que tomó el tiempo del arbitraje. Estos son algunos retos que están ahí, pero a lo que quiero regresar es que el Estado, en alguno de esos procesos arbitrales, ha invocado que no se pueden, por ejemplo, solicitar medidas cautelares contra el Estado, que algunas notificaciones deben hacerse de manera personal, y es interesante algunos criterios, incluso algunos pronunciamientos, pues que dan cuenta de que esas prerrogativas deben concebirse o comprenderse dentro del universo de procesos que se encuentran regulados por el Código Judicial. El Código Judicial, si bien tiene normas sustantivas, también es fundamentalmente un código con normas procesales o adjetivas, y lo que se ha estimado, y es el criterio que de alguna manera prohijo, con todo respeto, es que ese tipo de medidas cautelares perfectamente son viables en sede de arbitraje contra el Estado, no solamente porque la ley 131 de arbitraje así lo permite, sino que la misma ley 131 de arbitraje no establece ningún supuesto de excepción de forma que impida a una parte válidamente requerir este tipo de medidas cautelares contra el Estado. Si entendemos el Código Judicial como surgió a la vida jurídica de 1917, como me refería anteriormente, que era un proceso en materia de arbitraje regulado por el Código, que su impugnación se hacía ante la Sala Civil a través de recursos de casación en la forma y demás. Esas son normas que quedaron de alguna manera comprendidas dentro del contexto en el cual se aprobó el Código Judicial de 1917, y entiendo yo esas prerrogativas o privilegios como privilegios válidamente que el Estado puede ejercer cuando se trata de los procesos que se encuentran regulados en el Código Judicial. Procesos de ejecución de sentencia, procesos civiles, procesos contenciosos, no contenciosos, pero no un arbitraje que en mi opinión tiene una normativa jurídica independiente, y si el legislador patrio, bajo la ley 131, no comprendió ningún tipo de prerrogativa en favor del Estado, e incluso con la reforma constitucional del 2004, se reconoce válidamente por parte del Estado panameño los convenios arbitrales en lo que sea parte, me parece que oponer algunas formalidades o excesivos formalismos desdice un poquito de la misma razón de ser de estos procesos arbitrales. La experiencia que hemos tenido en procesos de arbitrajes pues ha sido interesante. El Estado se ha visto representado por apoderados debidamente designados, con los cuales prohija de alguna manera la legitimación o legalidad de esos procesos. En algunos procesos de arbitraje se ha permitido la participación incluso de agentes del Ministerio Público, en este caso de la Fiscalía de Asuntos Civiles, a quienes se le extiende pues participación para que pueda, junto con los abogados del Estado, llevar a cabo su defensa, pero son procesos en donde el Estado, desde el desarrollo constitucional que hemos tenido en el 2004, ha reconocido el carácter vinculante de estas cláusulas, por lo que un poquito lo que quería compartir es que podemos irnos quizás quitando ese chip o esa costumbre de que todo lo que huela o cualquier controversia que tenga que ver con el Estado tiene que desafortunadamente o únicamente ser debatida o en los tribunales administrativos, en este caso TAT, Tribunal de Contrataciones Públicas, y eventualmente Sala Tercera o Pleno en virtud de amparo de garantías, sino que existe esa posibilidad de, cuando se está en un tracto negocial con el Estado, indistintamente del contrato que sea, convenir válidamente estos compromisos, estas cláusulas compromisorias. Se pueden supeditar algún arbitraje institucional, como Cámara de Comercio, como el Centro de Arbitraje de la CAPAC, reglas CIADI, reglas ICC, pero lo interesante es que el Estado reconoce que hacia allá vamos, hacia un movimiento, por así decirlo, en la que pretende ubicar el arbitraje como un mecanismo interesante de solución de disputas y como una alternativa apreciable, sobre todo frente a la congestión que implica pues, supeditar cualquier controversia al órgano judicial, pues por todo lo que ello implica, la excesiva cantidad de procesos y todos los problemas harto conocidos. Entonces, básicamente lo que quería era, de entrada, compartir estas breves reflexiones, agradeciéndole nuevamente a los organizadores y sometiéndome con todo gusto a cualquier inquietud o pregunta que alguien tenga. Muchas gracias.
Gracias, José. Las preguntas las pueden ir presentando dentro de la parte de abajo de su pantalla, donde dice preguntas y respuestas. Nos pueden mandar las preguntas por escrito y luego de la presentación de Hans las vamos a ir contestando. Y si nos da chance, entonces, luego de contestar todas esas preguntas, podemos abrir los micrófonos para que hagan las preguntas a viva voz. Ahora lo que quisiéramos hacer es pasar a la segunda parte de la presentación. Vamos a cambiar a inglés para darle la bienvenida a Hans. Hans, welcome. Thank you for participating. For the audience, Hans Muig is an independent tax counsel specializing in international tax compliance and controversy. He assists corporate clients as well as governments. As tax treaty consultant, he has worked for various international organizations, including OECD, United Nations, and IMF. He is visiting professor at the International Tax Center Leiden and at the University of Amsterdam School of Law. He served as the Netherlands government as tax treaty negotiator, as competent authority in tax treaty matters, as prime litigator in tax treaty and EU law cases before the Dutch Supreme Court and the Court of Justice of the European Union, and as a delegate to the OECD Working Party No. 1 on the Model Tax Convention and member of its steering group. He chairs the Tribute Organization, an independent global initiative of leading experts in the international taxation, which seeks to spread awareness of tax arbitration and tax mediation among the global tax community. Expert for appointment as arbitrator or technical advice disputes on tax treaty or cross-border tax issues. So Hans, welcome.
Thank you, Klaus. So I've prepared a few slides, and if you could please, let's say, display them on the screen, yes, and then on to the second one, please. Now, I think the question often raised is, why do we need tax arbitration? Can those tax issues not simply be dealt with by the courts? But I mean, the reality is that where we see tax arbitration systems in place, it's often the courts that have endorsed it or even initiated its creation. And the problem with the courts is, and that's widely recognized, is that they have, let's say, in particular when it comes to international tax issues, a problem with expertise and capacity. Next to that, I think international tax issues, in particular those of, let's say, more factual nature, like transfer pricing determination, often require, let's say, more expeditious resolution. And quite often you see that the court procedures do not provide for a very quick resolution, in particular of those factual cases. So it's specific expertise, and it is, let's say, an expeditious resolution, which is a bit of a problem with the court system. Now, international law, I think international tax law, there is no world tax court. So there's also no, let's say, global institution to which those international tax cases could be transferred. And that's another problem. Second slide, please, Klaus. Yes, can you flip? Right. Tax arbitration, by contrast, does provide specifically for expertise and timely processes. Expertise, experience, because the arbitrators are typically people with a lot of expertise and experience in international, a lot of expertise and experience in international tax law. processes in arbitration are designed to be quick. There are various formats. I mean, baseball arbitration is probably known to you, US finding, which is ultra quick. But even, let's say, the more elaborate reasoned opinion arbitration is a process that ultimately doesn't take more than 2 years. Now, if you compare that, let's say, to ordinary court proceedings, that often is much, much longer. And I know of cases, in particular in Latin America, where even 30 or 40 years was not an exception. Another feature of arbitration, tax arbitration, is the informality of proceedings. And it's typically designed to prevent what we call lawyering, right? And I mean, most of you are lawyers, so probably know exactly what I mean. Let's say just discussing for the sake of discussing, but never coming to the content. That's typically not possible within this tight framework of arbitration. Arbitration, I think, in practice is most typically used to decide factual cases, factual determinations, in particular in transfer pricing cases. And in certain countries, actually, that was the origin of tax arbitration in the United States, where in the old 1992 Apple case, where the factual determination of the transfer price was made by the arbitral tribunal, and the decision of the tribunal was then incorporated in the decision, the eventual decision of the ordinary judiciary. So actually here you see another example where the decision in arbitration was very helpful, basically, and supportive of the court system. Maybe turn another one, yes. Unfortunately, we still keep seeing just the first slide, but nevertheless, I will simply proceed with my, my presentation. Precedents, people often ask me, I mean, tax arbitration, is that very rare? Are there any precedents in the world? And actually, there are much more precedents than you would think. But quite often, I mean, they're not always called tax arbitration. Really, tax arbitration tribunals, the proper tax arbitration tribunals, which are really an alternative to the court system, they indeed are, let's say, relatively scarce in existence. But one striking example is in Portugal. But if I would call, let's say, if you look at the point at the tax tribunals as you have in Brazil, which are basically at the pre-court phase, that's what I would also call tax arbitration. At the international, at the tax treaty level, you see already quite a bit of provisions for either voluntary or mandatory tax treaty arbitration. US, Canada is most best known example. In the EU, we now have, let's say, a new directive on tax treaty dispute resolution. The multilateral instrument of the OECD, where I think now about 30 countries actually have signed up to mandatory binding arbitration, including Singapore, which I think is a bit of an example also for Panama. The models of the UN and the OECD, and also your own IL-ADT model provides for tax treaty arbitration. Then we have investment arbitration on tax issues, right? And we see, let's say, really an increasing number of investment arbitration dealing with tax issues. I will come to that later on. Yet another example is contractual arbitration between states and investors. For instance, under tax stability clauses, which you often find in mining contracts, also in Latin America. But it may also be, let's say, between private parties under tax indemnity clauses, for instance. That's also quite usual. So actually, there's quite a lot going on in tax arbitration already, but we are not often aware of that yet. May I have the following clause? One of the prior former US international tax councils once said, well, tax arbitration is necessary, but it's not, let's say, the panacea for everything. And that's absolutely right. I personally always advocate a sort of what I call a holistic approach to tax disputes, meaning that you should have, let's say, sort of type of management, dispute management that secures you that you don't get too many disputes, right? But only those disputes that are worthwhile having. And that's in the interest, the mutual, the shared interest of both the tax authorities and taxpayers. Another element of the holistic approach is to avoid unnecessary causes of tax disputes, laws, for instance, that are unclear or controversial. That's entirely unnecessary. That's a matter of poor drafting. But some unnecessary causes can also be related to, let's say, compliance or enforcement cultures, which are not, let's say, adapt to the situation in hand. Very strong enforcement without communication with taxpayers obviously creates all kinds of unnecessary and avoidable disputes, while on the other hand, very poor compliance attitudes of taxpayers almost, let's say, necessitates authorities to become very aggressive. Another element of the holistic approach is dispute prevention, and we see, let's say, quite a bit of that emerging in recent days. Advance rulings also, of course, is the most well-known example. But I think what upcoming now are cooperative compliance programs, strategies for risk management, bilateral advance pricing agreements under tax treaties, all, let's say, aim to establish, let's say, a more cooperative, coordinated approach between authorities and taxpayers, but also between authorities of several countries together. And finally, part of the holistic approach is a reconciliation, possibilities of seeking a settlement out of court or even out of arbitration. Now, I think you need to have particular culture in a country to allow for settlements. And I think many, in particularly developing countries, are a bit hesitant in this respect because of the danger of corruptive practices. That's also always hovering, let's say, above the issue. But I think there are sufficient techniques, in particular by involving independent and reliable third parties, to secure that the scope for corruptive practices is very, very limited. The next one, please, Klaus. I understand that in Panama, you already have an arbitration law in place that theoretically would provide for the opportunity of tax arbitration, but that you don't have, let's say, any facilities as yet to make tax arbitration operative. Now, I think, yeah, so what would you need? You have the legal framework, right? But I think absolutely the crucial element for a proper functioning tax arbitration system is that it is trusted. And it is trusted for both the disputing parties, the authorities and the taxpayer, but also for the general public. And trust, I think, has to do with three main elements. First of all, the procedure of arbitration, right? It should be, I mean, not only effective, it should also be fair, and it should be transparent so that all parties involved can be convinced that this is indeed a fair and effective procedure that is worthwhile turning to. Second element is arbitrators that are qualified, right, that can actually do a good and fair job. Now, of course, I mean, you have all kinds of questions like whether they should be full-time or part-time or ad hoc, just for a particular case. And of course, very pressing question, where to find a good arbitrator. In particular, in, let's say, a smaller country like Panama, you probably need to cross borders to find a sufficient amount of qualified arbitrators. Then the third element is who will appoint the arbitrators. Well, I mean, you would probably think the government, that would be the most likely choice. But government-appointed arbitrators, well, may not immediately, let's say, be trusted by taxpayers. So what you see, for instance, in Portugal, is that, let's say, the arbitrators are appointed by an external body. They have a special arbitration, an independent arbitration institute that appoints the arbitrators. Now, then, of course, you need, let's say, more physical facilities like a venue that is equipped for hearings. You need to have, let's say, professional administration to support a proper proceeding. Usually that is entrusted to an external institution because, I mean, the government simply doesn't have the expertise and the knowledge to do that work. In Latin America, for instance, you have an excellent arbitration institute in Bogota of the ICC. I think determinative for, let's say, the amount of effort that you should invest in all these kind of issues is the number of arbitration cases that you expect. So the larger the number you expect, the more effort you have to invest in a truly professional and effective and reliable system. Next slide, please. We turn to what often is considered a very, very, very sensitive issue, the arbitrator qualifications. Most of the discussions on tax arbitration evolve around this particular topic. Who can we trust to be our arbitrator? And as said, I think if you deal with international tax issues, you should have international tax experts. And that's what we see expressed also in the multilateral instrument and the European directive and in basically all bilateral treaties that provide for tax arbitration. Tax experts are not necessarily people who are equipped to conduct a fair and proper arbitration proceeding. So quite often you see that a chairperson is appointed specifically to observe that the trial actually is fair, that the proceedings are fairly conducted and in conformity with agreed procedures. And that often is a former judge or even an active judge. Impartiality, that's another sensitivity. Obviously, I mean, arbitrators should be entirely impartial towards the case at hand. But the big question is, who can verify that? I mean, basically all the systems in place evolve around self-assessment on the part of the arbitrators. They have declared themselves in advance whether they are impartial to the case. And of course, they will always say that they're impartial. But who can police whether what they say is actually true? That's a big question, and quite open, I think, to date. Connected there is another question, and that concerns the position of private practitioners. I think there are quite a few countries and governments in the world who would consider private practitioners automatically non-qualifying as an arbitrator, right? Because they're assumed to be, let's say, partial against the government. Well, I don't think that's necessarily true. I can point at the example, as said, of Portugal, which does allow private practitioners and even active private practitioners to be arbitrators, and where, as a matter of fact, most of the arbitrations, and I have done quite a few, are actually won by the government, not by the taxpayer, despite the fact that they were arbitrated on by private practitioners. That's interesting, right? Now, a connected question is, I mean, could government officials be allowed as arbitrator, right? I think in Europe, I think government officials are member of arbitration panels, and many people in Europe are very unhappy with that. Another element often featuring in the appointment of arbitrators is nationality, right? So nationality of the country in question where the arbitration takes place. Well, I mean, looking at Panama, if you would only allow the Panamese to be arbitrators, in particular in international tax issues, well, do you have enough people, qualified people, to do that work? And also, wouldn't you like to have, let's say, a more international view in those cases, rather than just having a particular Panamese view, which might be a bit limited? What you see in most of the arbitration arrangements in tax treaties is that nationality or as a requirement are abandoned. So it's only the expertise, a proven expertise, that counts, and not the nationality. That said, I think where to find such an arbitrator who has, let's say, who's highly skilled in this international tax work. If you go to, let's say, the conventional arbitration institutes, you'll find mostly generalist arbitrators who basically can deal with any issue, but do not have, let's say, specific tax knowledge. My tribute organization to date is the only organization who actually offers international tax specialists for this particular work. And this is in line with a new and recent development in arbitration as a whole, where we see much more attention for, let's say, specialized tribunals, because of the recognition that the issues in arbitration often become so complicated that the ordinary generalist arbitration simply can't handle it anymore. Next slide, please. An issue which is currently heavily in discussion, in particular under the OECD proposals for the unified approach, it's the taxation of the digital economy, is whether the arbitration should be binding or not binding, or final or not final. And I mean, within the OECD inclusive framework, we see a lot of opposition from developing countries against binding arbitration. And so I mean, just had, let's say, a closer look into OECD documents on what they call the blueprint that leaked only this week. And I noted that this is an issue that the OECD has not resolved yet. Now, What I often wonder is what do countries mean by non-final or non-binding arbitration? Is it like that a party can simply say, I don't like the arbitral decision and I simply don't live up to it? Is that what it means? No. No, that's not what it means. If you actually look at domestic arbitrations in existence, you see that the non-binding character can have very different expression. First of all, I mean, there may be a possibility for review by other arbitrators or an appeals, let's say with a local court. I mean, review or appeals, that's quite extraordinary, right? Another, let's say, possibility, another, let's say, way of dealing with non-bindingness of arbitration is that there is often, let's say, an alternative offered for, in particular, for a taxpayer who is unsatisfied by the arbitral decision to still go to the courts and have the case presented anew, or as an alternative, to have the arbitral decision tested by the court. That's a bit of the situation you have in Brazil. Another example of non-bindingness is that even within the arbitral process, disputing parties are allowed or even encouraged to try a possibility of a settlement, right? Under the multilateral instrument and also the European directive, we see that the alternative of a settlement, even after the arbitral decision, is expressly offered for a limited period of time. And so that's another way, let's say, to meet, let's say, concerns that parties may have over whether an arbitral decision is fair or correct or not. The expressions of reservations that developing countries so far have expressed against the OECD proposals often deal with the issue of sovereignty, and that's sovereignty of their courts, right? Sovereignty of their courts. And let's say the alternative that I listed as number 3, bullet number 2 on the slide, could meet that reservation. So if you have a possibility for a taxpayer in particular, after the arbitral decision has been cast, to still have it tested before the court. Now that may sound quite unusual, but if you compare that with the ordinary MAP, a mutual agreement case, I mean, there the taxpayer in question already has that possibility, right? So why can a taxpayer, let's say, reject the outcome of a MAP procedure and still bring a case before court? And why couldn't he do the same in case of a tax treaty arbitration? That seems a bit unbalanced to me. I go to the final slide. And the final slide is, let's say, a quick comparison at the international front between tax treaty arbitration and investment arbitration. As said, I think we see the number of cases of investment arbitration dealing with tax issues, we see it rising. And I think there are two causes for that. First of all, because the number of provisions for tax treaty arbitration, while increasing, are still quite limited. In any case, far less than provisions for investment arbitration. Secondly, and probably even more important, is the fact that the taxpayer can actually trigger an investment arbitration and be a party in the investment arbitration. While in a tax treaty arbitration, he is not a party. At best, he is, let's say, a factual witness that can be called on by the arbitrators, but that even is not obligatory in most of the tax treaty arbitration provisions to date. So the taxpayer role in tax treaty arbitration is quite limited. That's not very comfortable for taxpayers. A third, I think, important distinction is that tax treaty arbitration only deals with double taxation, right? So it has a limited scope. And taxation, which is single taxation, but is unfair or inequitable in the view of a taxpayer, is simply outside the scope of tax treaties. You can only, let's say, fight that under investment arbitration. However, there's also a difference which is in favor of taxpayer, and that is cost. And the cost of a tax treaty arbitration are typically borne by the states themselves, not by the taxpayer. Now, I mean, the cost of an investment arbitration ordinarily are really high, in particular for a private company, or, well, not to speak of an individual taxpayer. So that is, let's say, a bit of an advantage. And there are also limitations on the scope of investment arbitration, not without importance. I've been myself in quite a few investment arbitrations as a expert witness. And in a number of them, I encountered, let's say, problems among the arbitrators, the generalist arbitrators, that they felt that the tax issues at hand were simply too difficult. Unfit is the term that they used for them to arbitrate on. So they simply said to the disputing parties, please, I mean, you should resolve it through some other way, but not through our arbitration. And another issue is that what you often see these days in investment treaties is that there's a carve out for tax issues that may be presented to tax treaty arbitration under a tax treaty, which is, I think, not unreasonable. But I think the more of those carve-outs we see, the less effective the investment arbitrations will become with respect to tax issues. I think that completes what I have to say, and I hope I didn't take up too much time of you at this early morning hour. Thank you.
Thanks to you, Hans. We appreciate very much your input. It was delightful. So now it's the floor open for question and answers. First, we are going to check out the questions we have on the question and answers button. José, hicieron una pregunta que respondiste a través del sistema. No sé si quieres agregar algo más o pasamos a la siguiente pregunta.
Sí, con gusto. ¿Aló? ¿Sí me escuchas?
Sí, te escuchamos. Sí.
Sí. Bueno, el video como que no está activado, pero bueno, sí. En efecto, la pregunta que hacía nuestro invitado, Klaus, era que si en esos arbitrajes se puede de alguna manera verificar una discusión respecto de que se estime que parte de la materia arbitrable vulnera o no normas de orden público. Y evidentemente en el tema fiscal, pues algunas consideraciones en ese sentido bien podrían hacerse, sobre todo en virtud del sistema legal impositivo imperante y que establece, pues, tanto en la parte sustantiva como adjetiva, algunos rituales que han de cumplirse y que ciertamente pues, serían motivos de discusión o podrían serlo de cara a la vulneración o no de posibles normas de orden público. Distinto cuando la controversia surge de una disputa contractual que no esté necesariamente relacionada con un marco impositivo, en el que evidentemente se podrían incorporar al debate normativas del Código Civil o del Código de Comercio, de manera que el riesgo de que se pueda suscitar una discusión en la que se tenga por disposiciones de orden público en un arbitraje en donde la génesis sea un conflicto de naturaleza contractual, pues son diferentes. Evidentemente habría que ver caso por caso y ver lo que se llega a plantear efectivamente en esos arbitrajes y confrontarlo o no con normativas local para ver si se puede llegar a la conclusión de que hay una vulneración o no de orden público. Esa es la pregunta.
Excelente. So the second question is for Hans. It was posed in Spanish by José Luis Galinde. It says, "Dear Mr. Hans, what is your opinion regarding the mandatory tax arbitration proposed by the OECD for the digital economy under Pillar 1?
Thank you, Klaus. Well, I think I fully understand why the OECD insists on mandatory binding arbitration. That is because there's so much scope of dispute under the proposals for the digital economy taxation. I mean, that is a very loose, flexible, subjective concept. And I think, of course, it has to be, because the OECD has to cater for many different tastes globally, right? So, I mean, I don't think they have any other alternative but to apply a very flexible, but to get at the same time also controversial concept. Now, this is why they actually need mandatory binding arbitration, because they too expect so many and very severe disputes that they can actually only resolve that through arbitration. Mandatory arbitration is also included in the Pillar 2 for the tax treaty abuse and anti-avoidance instruments. But that is less sensitive. The sensitivities are concentrated with the taxation of the digital economy. And if the OECD would abandon mandatory binding arbitration under Pillar 1, the result would be that we see, let's say, multiple taxation in many countries. I mean, if you look at, let's say, digital taxation as already in existence in India or in various European countries, and I think if we 1 year from now, we will see it in many more countries, all with systems that do not match at all. I think, yes, this will become a bit of a chaos, right? Mm-hmm. So that is why the OECD, I don't think, has any, let's say, other alternative but to stick to mandatory binding arbitration. But at the same time, running the risk that many countries, in particular developing countries, will simply not adhere to Pillar 1 at all, right? Not to arbitration, but also not to the concept of digital taxation that the OECD advocates.
Hans, can you share with us why would Singapore want to stick with mandatory arbitration under the MLI? Is there any policy reason you can share with us?
Yes, well, Singapore, as I said, is maybe, let's say, quite a relevant jurisdiction for you because it has a sort of similar economy, let's say, a hub, an investment hub with all kinds of, let's say, legal facilities attached. There are basically, I think, I've been to Singapore several times and also discussed this with authorities there. There are two reasons. First of all, that they grasp that under BEPS, they, with their specific tax system and facilitatory services, might easily become target of domestic anti-abuse and anti-avoidance rules of other countries. And if they would not have arbitration in place, they would be more or less defenseless, right? So they would need arbitration as the sole resolution to have, let's say, an independent, expert, reliable verdict, whether those foreign anti-abuse rules would be justified or not. That's reason number one. Reason number two, probably of lesser importance, is that tax arbitration fits well within their existing arbitration industry. They have, let's say, very large facilities for commercial and investment arbitration in place. And there's quite a bit of interest, I think, in the legal industry in Singapore itself to expand that to tax arbitration as well. Maybe that's also of interest to Panama with your refined legal industry.
That's perfect. That's perfect. So, is there any other question from the audience? We're reaching now the point of 1 hour of the webcast. So, if this is the last chance, well, I think everything is very clear. I thank you both, Jose and Hans. It has been a great activity. You have given us a lot of input. How important is arbitration? What is the current status? And you have the open doors for IFA Panama or similar events or any other cooperation regarding taxation. Thanks everybody for joining. Have a great day.